Good afternoon and welcome to this special sitting of the First District Court of Appeal in Bay County. First, we'd like to thank our hosts in the 14th Circuit today. We have one case on the docket. It is Union State Bank versus Eva Barnes and Sarah Blessinger. Counsel, if you're ready, you may proceed.
Thank you and good afternoon, Your Honors. May it please the Court, my name is Kyle Bauman. This is my law partner, Rick Peterman. We're from law firm Anchor Smith Brimley in Fort Walton Beach, Florida. We represent the appellant in this case, Union State Bank. I'd like to reserve 3 minutes of my time for rebuttal. Your Honors, procedurally, this is a very simple case and factually as well. Probably one of the simpler procedural and factual cases that has come before you in a while. But that simple procedure and those simple facts lead to a very narrow question of law. One that I believe is one of first impression in the state of Florida. That question is, does the recording of a certified copy of a final judgment of foreclosure and a final money judgment on the note and guarantees prior to the entry of any deficiency create a judgment lien on the non-exempt real property of the judgment debtor in the county of recording pursuant to section 5510(1) Florida statutes? In brief, this court should answer that question in the affirmative and reverse the trial court's finding that a judgment lien was not created. The reasons for that are primarily twofold, two general topics here. One is the bank did not engage in any premature collection activity or execution type activity that's forbidden by a line of cases beginning with Hammond, continuing on through Farrah. The second primary reason is that the judgment was final for the purposes of 5510(1) Florida statutes. And it's final.
The lien statute, right?
Yes, the lien statute, sorry. And that's because the underlying debt itself is established in that final money judgment.
Well, filing the lien doesn't do anything more than act like a bookmarker.
That's correct, Your Honor.
I mean, it isn't as if you have to pursue the lien, right?
That's exactly right.
You can, but it gives you the option of pursuing recovery through the vehicle of the lien.
Exactly right, Your Honor. And in fact, what it does, it establishes priority amongst perhaps other judgment creditors. But in and of itself, the judgment lien entitles you to nothing. You have to take further action, such as levying.
So you all are owed money, and you want to collect that money.
Yes.
There's two different ways of getting it, I guess. You can get a deficiency judgment, which you didn't have at that point.
No, sir.
Right? There's no money judgment at that point. So filing the lien was essentially another avenue of seeking recovery of the monies that you believe were due to you.
Well,
or is to secure the property against which you could try to get recovery.
it's to secure our priority to that property amongst other judgment creditors in the event that we eventually try and collect on that property, the non-exempt. And just to be clear, Your Honor is probably aware of this, but the property that we believe our judgment lien attached to is different from the foreclosed property in the underlying.
Does that matter?
I don't believe it matters. I just wanted to make sure that the court understood that fact.
Does it matter to this extent that the lien was placed based on a judgment against a particular defendant who owned the property at the time, correct?
That's correct.
Did that lien survive when that defendant sold that property to a new owner and the bank did not seek to attach the proceeds of that sale?
Yes, Your Honor. I don't believe there's been any argument contrary to that. The lien itself, once it attaches, it's not extinguished by any action except satisfaction of that lien. I don't believe there's any law or authority that would support the extinguishment of that just because the property changed hands.
Is there any law or authority to support that the lien continues when the defendant against whom the lien was entered has sold or otherwise transferred that property?
I'm unaware of any law in either direction on that point, Your Honor. I think the general law relating to liens would suggest that the lien continues until it is extinguished through satisfaction of that lien or the underlying debt.
Or the withdrawal of the lien. You could withdraw the lien.
Certainly affirmative action by the judgment creditor, such as withdrawing the lien, would extinguish the lien.
I mean, if you got a judgment for everything you're seeking for in the deficiency matter, you wouldn't need the lien anymore, right?
That's right. If the underlying debt itself is satisfied, then I think the lien is extinguished at that point.
So the new purchaser of the property requested that the bank release the lien, correct?
Yes. So So the original debtor in this case, a gentleman named Flynn Morris, sold the property to Barnes and Blessinger, and Barnes and Blessinger, and the lien was not picked up by the title company at that time. So now Barnes and Blessinger are seeking to sell the property again, and at that point, the lien was picked up.
Right, and the bank would not withdraw it.
That is correct.
All right, why isn't that considered execution?
It's not execution, Your Honor, because simply not withdrawing the lien does not entitle the bank to anything. It still is going to have to levy on the property. I will give you that the property itself, the marketability of the property is impaired, but simply impairing the marketability is different from collecting or executing on the underlying judgment.
Counsel, let me ask you about the chronology. So the foreclosure judgment on Mr. Morris's property and guaranteed with the note was 2010.
Correct.
And Mr. Morris sold one of those lots to these FLEs in 2014.
I believe that's correct.
And when did the bank seek to have a trial court adjudicate the amount of the deficiency?
So I don't want to speak outside the record, Your Honor, since the final summary judgment is, that was obviously a separate proceeding, when the bank foreclosed the property and got the note and guarantee judgments. Of course, in that case, the court could theoretically, or the judgment creditor could theoretically establish a fair market value credit for the property or sought a deficiency. Again, I don't believe that's inside the record of this case. So I don't want to definitively say, speak to that. But regardless, I think that the entry of the deficiency, that's really the central point of this case. Our whole point is that I'm glad I was able to correctly identify that. Our whole point is that the deficiency itself, whether or not it was entered, is really irrelevant to the facts of this situation. And the central question to this case of whether or not a judgment lien is established at the time that our clients recorded that certified copy of the final judgment in the public records of Walton County.
Isn't it relevant to the extent, though, that in terms of determining the amount of the encumbrance on the property, that there's been no valuation of the deficiency, and there has been no valuation under the statute that directs how that valuation should be calculated?
Yes, Your Honor. I think that we're still at the preliminary stage, which is simply the bank has established its priority amongst other creditors at this time. Certainly, if the bank is to take further collection or execution type activities, then the fair market value credit that is owed to the judgment debtor is certainly relevant and could be litigated at that time.
And how is that established under Florida law?
It can primarily, usually it's done through a deficiency judgment. There are also various other techniques depending on the collection activity taking place. For instance, in a proceeding supplementary, the judgment debtors will get a notice to appear, and then you can litigate the amount of debt that's at stake, essentially.
Do you have any authority where that valuation has occurred, where the creditor has already obtained a foreclosure judgment, but not yet obtained a deficiency judgment? I'm try and answer your question as clearly as I can as it relates to this case. I think that I don't believe I have any authority directly on point to support that proposition. But again, I think that if you go back to the central question of this case, which is simply, is there a judgment lien or is there not a judgment lien? There is a line of cases starting in the Florida Supreme Court, and they are old cases, but I believe they have not been abrogated and they're still in effect today. Starting with the Massey v. Pineapple Coke case, Young v. McKenzie, Mosley v. Doe ex Dem Edwards, that state that judgment lien arises merely as a function of the statute, and that those cases contemplate that merely recording that judgment is a separate activity from an execution or collection type activity. And there's been, again, these are very old cases, I admit, they're Florida Supreme Court cases, but they're very old. And they address the law when it was slightly different. There was a lot more Latin in the law back then.
But the central holding there was still a statute in effect that would create a judgment lien when a certified copy was recorded in the debtors, in a county where the debtor had non-exempt real property.
Do those cases predate the enactment of the deficiency judgment statute?
I believe all of them do. However, later on in a third district case of Gantz v. First National Bank, that Florida Supreme Court line of cases was cited with approval. Gantz is not a foreclosure case. I'm not saying it's on all fours with this case, but I think Gantz demonstrates that those Florida Supreme Court cases are still good law as to this very particular point. Now, of course,
Let me re-ask the question. In the foreclosure context, subsequent to the enactment of the deficiency judgment statute, is there any case law that supports your theory on liens?
I think, again, I do think that the Gantz case does establish that Florida Supreme line court of cases is still good. It's still good law. And so in that way, I believe that, yes, that the law is current in that regard.
If we reverse here and allow the lien to be in place, describe to us how your client is made whole through the deficiency judgment or through the lien, levying on the lien sort of process.
I'm sorry, could you?
Yeah, if the lien is back in place, we reverse. Mm-hmm. How is your client going to be made whole in your view? Is it through the deficiency judgment and the lien, or both, or what?
So for
how much is owed?
Yeah.
I'm trying to get this down like brass tack. What are you seeking? You're seeking money, right?
Correct.
Okay, one way is to get to the deficiency judgment.
Right.
Another way is to have an action on the lien, to try to collect the lien on this.
Well, let me clarify that the deficiency judgment, so the underlying debt that is due is established in the final money judgment. The deficiency judgment, yes, it establishes the credit that is owed to the judgment debtor. So I do believe that that's a little bit different from what we have here, which is we've merely refused to release the bank has merely refused to release its lien on the property in this context where there will be proceeds from the sale. So we would continue to refuse to release, and it depends on how the buyer and the seller would elect to proceed.
Because what I'm getting at is I kept reading in the case law about this fear of double recovery.
Yes.
And I'm trying to understand that in this context that we have today. Where is the potential for double recovery by your client?
We believe that there is no potential for double recovery in this context because the judgment debtor, again, because we haven't taken any execution or collection type activities, the judgment debtor there's no danger of any double recovery. The judgment debtor would have full rights and full opportunity at future hearings to assert how much that fair market value credit, if it has not already been established in the other case, how much that credit is worth and how much they should be credited against the underlying debt.
But counsel, how can you do the math without getting a judge to tell you what the deficiency is? I know that in your affirmative defenses, the bank says it's a $550,000 property at the time of the foreclosure sale, but we don't know if you've collected anything else. These ladies who own this property don't know if you've collected anything else. So where does the math come from without a deficiency judgment? And while I've got your attention, could you address the statute of limitations?
The statute of limitations on the deficiency judgment, right? Let me take that topic first. The statute of limitations, there is a statute of limitations for the deficiency judgment, but there's a lot of ways that you can establish how much credit. And again, I think that's the key point here is the debt's established in the final money judgment. You got to determine the value of the secured property on the date of the foreclosure sale. There's a lot of different ways you can do that, not just through the deficiency process. And the statute of limitations is not run on those other methods that could be used to determine that.
Okay, but on the math, how do you know based on what evidence, not just what's in the bank's head, if the bank has a head where it can think about that, how do you know that there is still a debt owed as to these ladies' lot?
Well, Your Honor, because theoretically in the final summary judgment case, it is not this case, the court, it's judicially determined what that fair market value credit is, and then you can subtract that amount from the underlying debt itself.
But that had not been judicially determined at the time these lot owners asked you to release the lien.
That's correct. But again, that's irrelevant at that point because that's merely a lien. We're not collecting or executing.
Pretty relevant to them.
Well, now that you've collected something, it sounds like in this other proceeding that we don't know anything about because it's not on the record, wouldn't they point to that and say, oh, well, you've gotten what you're entitled to, releases from our lien? Wouldn't it be on them to do something at this point?
To be clear, I'm not saying that there's been any collection activities. I'm just saying that perhaps in that other proceeding, there could have been a determination of the fair market value credit that is owed on that underlying debt.
And I mean, I think it's also important here where you have multiple defendants in the original judgment, correct? And jointly and severally liable. So we're not just talking about one defendant and what credit might be due based on collection. We're talking about multiple defendants and foreclosure that has occurred. So is outside the deficiency process subsequent to a foreclosure, is there any other proper way to value this property, given all the credits due?
I think that the way to value it is on the judicial level and must be determined by the court, and both sides present their evidence as to that amount, and that would occur in the final summary judgment proceeding. Your Honors, I see I'm out of time. If Your Honors have further questions, I'll stay up here, but if not, I'll take my seat.
Thank you, counsel.
Thank you.
I see you're in your rebuttal time. I will extend the 2 additional minutes for your rebuttal, and I will add 2 minutes for the appellee.
Thank you, Judge.
I'm happy to have those deducted from my time if that would be. May it please the court, I'm Robert Powell and I represent the appellees. This court should affirm. The trial court correctly determined in its summary judgment that the bank did not attach any lien to the real property that the appellees acquired from one of the bank's judgment debtors. And actually to reverse the trial court would require this court to articulate a new rule of law in Florida that would undercut this court's own precedent and be contradictory to virtually all of the other DCAs that have weighed in on this deficiency process.
Counsel, how do you respond to the bank's argument that this is just a lien? It's just something, you know, that flows from, they filed a foreclosure judgment, just like everybody does, and they haven't done anything. How do you respond to that?
Yes, Your Honor. My first response would be that it's not a lien because the form of the judgment that was recorded is impermissible in the state of Florida. The 3rd DCA most succinctly articulated that in Fair versus Iberia Bank in 2010. It's impermissible to obtain a foreclosure judgment that sets a judicial sale and then simultaneously purports to allow the creditor to execute on the underlying money judgment. The 3rd DCA cited the 5th DCA decision in American General Finance versus Graves. This is not new law in the state of Florida. That's fundamentally impermissible. So my first response would be there was no lien that was created. But even if we go more to the point that this is just a lien, this is not a collection or execution activity, I would also disagree with that. I think it's a little bit disingenuous because it's the very reason we're here. The recording of the lien, if it's valid, is what formulates the basis of the bank's demand for the sale proceeds from the appellees, who were strangers to the original foreclosure action, had no opportunity to challenge any deficiency that was remaining, had no opportunity to, as I believe each of your honors pointed on to, determine what amount remained due and owing to the bank, if anything, after this judicial sale was conducted. So that's the problem in this case. There was a foreclosure sale in January 2010. The bank took no further action, Judge Kelsey, in response to your question, chronologically for a period of nearly 7.5 years. It was actually Exhibit A to their affirmative defense. Page 21 of the record shows this motion to establish credit against judgment, which was in reaction to the declaratory judgment complaint that the appellees filed in this case. No action for a period of 7.5 years, incidentally, after the 5-year statute of limitations that governs commencement of deficiency proceedings. The issue is that the lien, to the extent it even attached, does not liquidate the debt that remains due and owing to the bank. Hypothetically, let's say this was a $10 million property that were being sold. If the bank had unilaterally credited some amount without obtaining a deficiency judgment, there's no real, that you have the safeguard of judicial oversight to determine if that's an appropriate credit, a fair market valuation of the property that's been foreclosed. That didn't happen here. So how would the appellees, if they were selling this property for, say, $10 million, far exceeds the $2.3 million original judgment, what amount do we owe you, bank? We want to release your lien so we can transfer marketable title. The bank wouldn't be able to answer that because they don't have a deficiency judgment. That's the fundamental issue and the defect in the process.
Well, they could resolve it with you. I mean, that's one way with have judicial finality. But they certainly could resolve the case along equitable, agreeable terms, right?
Well, if Your Honor is alluding to just negotiating a release of the lien, yes, absolutely. But again, that presupposes that the lien actually attaches. And because of the form of the judgment, because of the bank's failure to have obtained a deficiency judgment, which all the DCAs require, that there's no certainty, there's no actual attachment of that lien in order to negotiate a satisfaction. There's nothing to negotiate. Hammond versus,
Well, let me follow up on the lien itself. I think I'm reading between the lines, you can tell me if I'm wrong, but if the title company didn't pick it up, your clients bought this property when it had a lien on it, and they didn't know that. So obviously, there's a problem with the title company. I don't know if there's any litigation on that, but it seems to me that, aren't they, they should have picked up this lien. Would they have been able to buy the property with the lien on it, or would they have bought it with notice of the lien?
I think you could arguably infer that by virtue of the title company not picking up the lien, it was analyzed. This judgment was likely reviewed and examined in the abstract, and because it was a foreclosure judgment that set a sale under Hammond versus Kingsley Asset Management, under Royal Palm versus PNC Bank, it doesn't attach a lien. There was no
But
deficiency.
that's all speculative. We don't have anything in the record.
Understood.
Someone did that, right?
That's correct.
Okay, I mean, that's just pure speculation today.
Yes, sir.
We don't know why the title company didn't pick it up.
That's correct. That's correct. What's not speculation in this case is that we have Hammond versus Kingsley Asset Management, the second DCA, that said in 2014 that if you foreclose, if you elect foreclosure relief, you are wed to the deficiency process. You have to get a deficiency judgment before you collect any further. The third DCA in FARA most succinctly encapsulated the rule of law. We disapprove any effort to reach the personal assets of the mortgagor unless, until, and only to the extent that a deficiency judgment is rendered in accordance with the trial court's exercise of discretion.
But isn't that a judicial policy call that's been made by those courts? I don't see anything in the statutes that prohibit it. Florida legislature hasn't said they can't do this.
I think that's correct, Your Honor. I think
it's just some court trying to find a pragmatic solution.
right, but what we have is you have one case that weighed in, Century Group versus Premier Financial Services, also a second DCA case from '99. Then Judge Quince, who said, wait, you can't even take discovery. If you foreclose and you don't get your deficiency judgment, we're not even going to allow you to get discovery in aid of execution because it might be unnecessary. We don't even know if there's going to be any amounts that remain due and owing. A bank doesn't get to just unilaterally decide based on an appraisal that may be in a loan file that, hey, we're going to credit, as their first affirmative defense of the complaint says, $550,000 to this foreclosure judgment debt, and we've still got $1.9 million roughly that's due and owing. That's not how it works. There's a competing evidentiary determination with respect to the valuation of the fair market value of the property.
The struggle I'm having, you say that's not the way it works. But you can't point to a statute that says that's not the way it works. And you point to some cases in which the courts were worried about double recovery. And they're saying, well, as a matter of judicial policy, we're going to say if you pursue this line of recovery, you can't pursue this line of recovery. It's sort of like an election remedies idea, I suppose.
Yes, and
But it wasn't, those cases weren't based on a statute or anything else. It's just the courts decided that's what we think is the fair way to do it.
Yes, Your Honor. I think that the statute that most closely governs is 702.06. Judge Rowe, I believe in response to your opinion, or your question to the bank, is there any case law after the adoption of, I think it's the 2013 version of that statute that supports the bank's position? The answer is no. In fact, there's not any case law in Florida that endorses the approach that the bank took in this case. Policy is important, Your Honor. Judge Maycart, you hit the nail on the head. The underpinnings of all these cases is the double recovery concern. That issue is paramount in this situation, and that's prevalent here because you have to have judicial oversight in the process of determining, is there anything that remains due and owing? 702.06 commits this proceeding to the trial court's discretion. So it's not a guarantee that you're going to get a deficiency.
But let's take the appellant's argument. I mean, let's assume that a lien did attach. And so how is this new trial court to determine the rights, not just of your client and of the bank, but to strangers to this transaction, the other defendants against whom money judgments were entered, and the defendant who sold the property to your client?
Yes, Your Honor. So the appellees, as you identified, are not parties to the original foreclosure action. They filed this declaratory judgment action just to determine that the judgment that was recorded did not attach any type of lien. It's not been any relief that's ever been sought in front of Judge Green, the trial court that rendered the judgment that's now on appeal, to liquidate or determine what amount, if any, remains due to this bank. So that's kind of, again, it all hinges on the failure to obtain a deficiency judgment. This court even acknowledged that that's a requirement. Blue versus Covington County Bank in 2012. That was a case that involved Lloyd Blue, a guarantor of a commercial loan, There was a foreclosure judgment. The property was sold, and the trial court ordered a credit, initial credit of $1.3 million, and reserved jurisdiction to determine if actually there was an even greater credit that might be warranted based on the fair market value of the property. Mr. Blue took that up on appeal. This court ultimately dismissed it as premature because that type of judgment was not final for appellate purposes because the trial court's judicial labor hadn't concluded. The court had not finally liquidated the amounts that remained due and owing under that foreclosure judgment. Arguably in dicta, this court specified that once you go the foreclosure route, you've got to get your deficiency judgment. So it's virtually unanimous. There's not really any disagreement among the district courts of appeal that this is the process. You have a procedural safeguard at the remedy election phase of the case. You can go execute upon your money judgment if you don't want to foreclose, but as Royal Palm versus PNC Bank clarified, we're going to withhold setting the judicial sale creditor until you come back and certify that you've not collected or the extent to which you've collected your money judgment. Because we've got a safeguard against a double recovery. It's axiomatic. You can only recover the debt one time. There's no dispute about that. The parties agree about that. And so that's again, the procedural safeguard that Florida appellate courts have fashioned to assure that there is no double recovery.
Was the lien, in your view, improper as to Mr. Morris? In other words, Morris owned the property, correct?
Yes, sir.
At the time the lien was put on,
Yes,
he
sir.
owed allegedly some money.
Yes, sir.
Okay, so was there anything improper about doing the lien at that point in time, putting your client's interests aside? They came along.
Yes, sir. Yes, sir. I don't see any clear prohibition in the case law about the perfection of a judgment lien if you elect to collect on your money judgment first. That's not the situation that we have here. The bank here elected foreclosure relief, which then requires a reduction of foreclosure judgment through a deficiency proceeding to then determine if there's any amount that remains secured by that lien.
So if your clients hadn't bought the property and they had pursued a deficiency judgment and got a deficiency judgment, couldn't they, if they felt they were still owed more money, go against the property under the lien owned by Mr. Morris?
I believe that might be a correct result. But the reason there's no double recovery risk if you pursue your money judgment first and then go to foreclosure is that you're required, as the PNC Bank case illustrates, to credit the foreclosure judgment debt with any assets that you encumber with the recording of that lien. So that's the sort of the safeguard to assure that these, the equitable remedy of foreclosure and the remedy of law of execution on a money judgment does not result in recouping a greater amount than the judgment debt that's awarded. Yes, Your Honor.
Well, let's assume that the lien did attach, okay? In that case, does it survive the transfer of the property from the defendant against whom the judgment was entered? What does the case law say about that? What does the statute say about that?
Yes, if you transfer property that's subject to a judgment lien and it's non-exempt property, not homestead property, the lien is going to travel with it.
Okay, so you don't dispute that.
Same result generally in bankruptcy. That's not going to discharge that lien absent a strip off proceeding.
Why is it the title company in this case?
Your Honor, I'm not sure that I'm lawfully permitted to address
Well,
the
if that's on the
exist-
record,
yeah.
then don't. But I'm just
It's not in the record, Your Honor. I don't mean to be coy about that, but
okay, that's fine.
yes, sir. Yeah.
Counsel, would your clients not have an adequate remedy, if it does get to the point where actual execution is attempted, there would be a new proceeding, and they could assert all their defenses then, including demanding proof of a deficiency judgment. How much do you actually owe? How much have you collected from other people? Why are you bothering us? Don't they have an adequate remedy in that respect as well? And, with respect to the limitation on the marketability of the property, isn't that between them and Mr. Morris?
Judge, I'm not sure that I do agree with that. The proceeding supplementary process, the notice to appear that's contemplated by 5629, is for third-party individuals that have received fraudulent transfers of assets that were otherwise subject to execution. It's not appropriate in my opinion, in the foreclosure case to bring in third parties that have received a post-judgment transfer. You have Chapter 726, the fraudulent transfer avoidance statute, that would enable you to then sue those third parties. But I don't believe that 5629 and the notice to appear is what's contemplated in that process there. I think does that answer your question? Okay. The bank relies on this old arcane line of Florida Supreme Court cases Massey versus Pineapple Orange, Mosley, Young, etc., none of which apply today. Those cases, if you can read them, they took me about a dozen times because of all the Latin, involve arcane principles of judgment execution law that no longer apply. Section 2817 of the revised general statutes, that statute no longer exists, obviously. We have 5510 that we're dealing with today, and the writ of Siri Facius, I believe I pronounced that correctly, is an arcane principle of judgment execution law in Florida that's no longer applicable. Recording a judgment is the first indispensable step in the execution and collection process. Florida Rule of Civil Procedure tells us that 1.550A, no execution or final process shall issue until the judgment upon which it is based is recorded. So this is the linchpin of the case, is whether recording a judgment that impermissibly grants foreclosure relief, setting a judicial sale, simultaneously purporting to allow the bank to collect on the underlying money judgment, whether that attaches a lien. In response to the very first question, I said, I don't believe there's no lien in the first instance. The bank's entire argument presupposes that there was attachment of a lien.
I thought you agreed with me that the lien was valid as to Morris at the time it was imposed.
Well, I think that if you were to elect to collect on your money judgment first without having elected foreclosure relief, then I believe I agreed that the lien might attach in that instance. But in this case, the bank clearly elected foreclosure relief and the court scheduled a judicial sale for January 2010. So that's the duplicative relief that is impermissible to grant.
But what if they only get 50% relief through the mortgage foreclosure process? Can't they go against this other asset?
Absolutely, after obtaining a deficiency judgment to determine that 50% of the judgment debt is still due an
But
element.
isn't it a prudent practice to just go ahead and put the lien on the property that Morris held at the time because they knew they were going to go probably after the property to satisfy the judgment?
Well, I think that's perhaps, I don't know that I would concede that, Your Honor, because nobody knows the results of a judicial sale. Regardless of whether the fair market value of the property according to an appraisal.
But you're not saying they have to go through the whole process, litigate it through the deficiency, then they can put the lien. I mean, lien is typically done defensively. Oh, we want to protect our right here. We want to be first. Lien holders want to get in right away.
Understood, which is a form of execution or collection, which if you've pursued your foreclosure remedy, if that's the remedy that you elect first and foremost, you're foreclosed from going forward with any collection effort. As the third DCA said, we disapprove any effort. Century Group versus Premier, you can't take discovery. Hammond versus Kingsley Asset Management, you can't garnish. You can't perfect a lien, would be the logical extension of all of these cases, unless, until, and only to the extent a deficiency judgment is rendered. Again, the concern about fraudulent transfers, there's already a comprehensive framework to avoid those. If getting the lien in place to prevent a gift, sale, or transfer of the property is the concern, you've already got a protection and safeguard for that in Chapter 726. Your Honors, I see my time has expired. There's no further questions.
Thank you,
Thank you.
I believe that my opposing counsel, friend Robert here, has hit on the central point of this case, and that is, should this court choose to extend that Hammond line of cases to situations like this, where there is simply a lien arising as a function of the statute? The bank, of course, emphatically contends that the answer is no, that lien, the recording of that certified copy, is not by itself a collection type activity. It's not an execution. Mr. Powell hit on Rule 1.550 in his argument. And he's correct that that rule does address both execution and the recording of the judgment. What that rule says is that before you can execute on that judgment, you have to record a certified copy of the final judgment in the public records of the county that you obtained the judgment in. So that presupposes, the execution presupposes the filing or the recording of that certified copy of the final judgment. And also, if you look at the structure of Florida statutes, Chapter 55 and Chapter 56, Chapter 55 deals exclusively with judgments. Chapter 56 deals exclusively with execution. You would expect that if the recording of a certified copy of a final judgment was an execution or collection type activity, that is where that statute would be found, but it's not found in Chapter 56. It's found in Chapter 55, 55.10(1) specifically, leading this court to the inescapable conclusion that it is not an execution activity, it's not a collection type activity, it's something different from that Hammond, that Farah v. Iberia Bank line of cases. It's distinct. It merely arises as a function of the statute, that lien.
So counsel, if I could take up this last 10 seconds. So basically you're saying the lien is just a shell. It exists independent of a quantification, which will come later.
Exactly. And the judgment debtor will have ample opportunity to establish what credit is owed to it in those other proceedings. Thanks, Your Honor.
Thank you, counsel. Thank you all. This court will stand adjourned.